benching is a big issue. Benching is a big issue. The H-1B workers must be paid the agreed upon salary, which is a part of the certified LCA, is a minimum of prevailing wage or actual wage, but the wage has already been certified or approved by the Department of Labor, which was also been incorporated into the I-129 Phase 5 Part 5, making both the FTNS as well as the DOL audit subject. Okay? So, that particular amount, which was stated in the LCA and the I-129 Phase 5 Part 5, must be paid to the H-1B worker, regardless of whether worker is working or not working. It really doesn't matter. Your obligation starts when the worker became available to work within 30 days of arriving in the U.S. See the catch? The H-1B workers arrives in the U.S., let's say came in October 5th. October 1st, H-1B starts. October 5th, H-1B worker arrives. By November 5th, you must put this person on payroll. Whether you have a social security number, you have a project, you have a job, does not matter to the law. It does not matter. You must put this person on payroll within 30 days. So you might have to put before 30 days. If the person came to your office and made him or her available to work, or you took his or her resume and you started to market this person in the IT market, you started to send to the end client. That means the employment has begun. You must start to pay. So the people who came from overseas, their payroll must start within 30 days. You cannot cross 30 days regardless. So if they do not come to your office within 30 days, you have a right to withdraw the H-1B petition, which was approved. Or you start to run a payroll. But if they make themselves available to work before 30 days, like right very next day they come to your office, orientation, start to market, fill out I-9, the employer-employee relationship has started. So make sure start to run their payroll from that day. So if you do not pay, now you have a benching. And you could be liable for back wages if the person files a complaint at the DOL or there is a site visit of other employees and this fact came in. Now you have a back wage issue. Now another group of people who are on F1 visa, L1, H4, L2, or any other visas, J1, they file a change of status in the United States, and now the United States could be cap exempt H-1B or cap H-1B starting from October 1st. It could be any scenario. For these people, your obligation is you must start the payroll within 60 days. So on a 60th day, if you haven't put this person on the payroll, you must withdraw this H-1B or start the payroll. Now, if they made themselves available before 60 days or any day before, that is your start day of the payment. You need to start to pay in order to not to incur back wages. So there are two government agencies involved in monitoring the back wages. You have FTNS, which does regular site visit under the H-1B modernization rule. It's been codified. Employer must cooperate, otherwise they can issue NOID and cancel the H-1B. So, having said that, the DOL equally has full proof authority to do the investigation. They might randomly investigate the company, or they might get this news from the consulate because some employee went there, they were in benching, or their W-2s were very low, or some disgruntled employee might file a complaint. So any source of this notification would result in the audit of H-1B audit by the DOL or FTNS site visit. So in order to remain compliant and satisfy the legal requirement, you must pay the wages from the date the employee joins the company.